Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 332206. Case is styled the state of Texas versus Elvis Trevornier Cruz. Mr. Cruz is appearing via Zoom. Mr. Cruz, he speaks Spanish?
I believe he speaks English.
Speaks English? Okay, Mr. Cruz, you can take your mic off of mute. Okay, how you doing, Mr. Cruz?
Good, and you?
I'm doing fine. Thanks for asking. Mr. Cruz, you're here represented by your attorney, Jerry Gilthorpe. Mr. Gilthorpe, how are you doing?
Doing well, thank you, Judge.
Mr. Gilthorpe, what is your announcement in Mr. Cruz's case?
We need that placed on a trial docket.
Reset it for trial?
Yes, Judge.
Okay. Okay, we're gonna give you a trial date. Just hold on.
Okay.
The date she's been given is March 6th of 2023.
March 6th. That date works for me, Judge.
That day works for you?
Yes, sir.
Okay, so this case is gonna be reset until March 6th of 2023. Mr. Cruz, your attorney will give a notice of your reset date for March 6th, 2023. Stay in contact with your attorney. You're free to go and you have a blessed day.
Okay.
Thank you. And Mr. Gilthorpe, you'll be able to get your reset from our court coordinator.
Yes.
Once you get your reset, you'll be free to go and you have a blessed day.
Thank you, Judge.
You're welcome.
You can log off, Mr. Tavera.
I'll get him if you
You can log off.
Yeah, okay. No,
Kenneth Sylvester,
not here.
you not on this docket?
Mm-mm.
And must have got moved. Okay.
Next case is cause number 325941. Case is style of state of Texas versus Caleb Williams. Caleb Williams is scheduled to be in court this morning for the court's announcement docket at 9 a.m. At or about 9 a.m., Caleb Williams' name was called at the courthouse door by the court's bailiff. Caleb Williams did not answer. Caleb Williams has not appeared since the court has been in session. The time now is 10:22 a.m. on today's date of December 14th of 2022. Mr. Bailiff, would you please call the name of Caleb Williams at the courthouse door? Okay. No answer from Mr. Caleb Williams.
Okay.
When his name was called at the courthouse door by the court's bailiff. Caleb Williams has not appeared in court since the court's been in session. Caleb Williams has been given a reasonable time to appear in court. He has not appeared in court. State, do you have a motion?
Yes, Your Honor, state moves to bond forfeit.
That motion will be granted. Caleb Williams' bond will be forfeited and the warrant should be issued for his arrest in cause number 325941. Next two cases are cause number 325965 and cause number 328477. Both cases are styled the state of Texas versus Omar Madrano. Omar Madrano was scheduled to be in court this morning for the court announcement docket, which was scheduled at 9 a.m. on today's date. At about 9 a.m., Omar Madrano's name was called at the courthouse door by the court's bailiff. Omar Madrano did not answer. Omar Madrano has not appeared in court since the court has been in session. The time now is 10:23 a.m. on today's date of December 14th of 2022. Mr. Bailiff, would you please call the name of Omar Madrano at the courthouse door? Omar Madrano. Omar Madrano's name was just called again at the courthouse door. Omar Madrano did not answer. Omar Madrano has not appeared in court since the court's been in session. A reasonable time has passed to give Mr. Madrano an opportunity to appear in court. He has not appeared in court. State, do you have a motion in each case?
Yes, Your Honor, the state moves for bond forfeiture in each case, Your Honor.
Omar Madrano's bond will be forfeited and the warrant should be issued for his arrest in cause number 325965 and cause number 328477. Next case is cause number 331-295. Case is style of state of Texas versus Karen Beauchamp. And she also has another case, cause number 331-297. Both cases are style of state of Texas versus Karen Beauchamp. Karen Beauchamp was scheduled to appear in court at 9 a.m. for the court's announcement docket scheduled on today's date of December 14th of 2022. At or about 9 a.m., the court's bailiff called the name of Karen Beauchamp at the courthouse door. Karen Beauchamp did not answer. Karen Beauchamp has not appeared in court since the court has been in session. The time now is 10:25 a.m. on today's date of December 14th of 2022. Mr. Bailiff, would you please call the name of Karen Beauchamp at the courthouse door? Karen Beauchamp. Karen Beauchamp. No response. Karen Beauchamp's name was just called again at the courthouse door by the court's bailiff. Karen Beauchamp did not answer. A reasonable time has passed to give Ms. Beauchamp an opportunity to appear in court. She has not appeared in court. State, do you have a motion in each case?
Yes, Your Honor. The state moves for bond forfeiture in each case.
Karen Beauchamp's bond will be forfeited and a warrant should be issued for her arrest in cause number 331-295 and cause number 331-297. And this will conclude the calling of the court's announcement docket scheduled for December 14th of 2022. The court will be in recess. Good morning, Mr. Crawshaw.
Hi, Judge. Good to see you.
Nice seeing you as well. I have a copy of your motion for return of property pursuant to Article 18.19 of the Texas Code of Criminal Procedure that you filed on behalf of your client, Clay Elwood Artery III.
Yes.
Mr. Crawshaw, are you ready to go forward?
1 second, Judge. Let me make sure I'm pulling it up. Okay.
Is this?
Okay. Yes, Judge.
Yeah, hold on a minute. I need to get my court coordinator to pull up something for me.
And Mr. Shearer, when I emailed the court about this, Mr. Shearer said that he was not opposed to it.
Oh, Cheryl's handling it?
Well, yes, he's been handling the case since a long time ago, but he's not opposed to the motion.
Yeah, okay. I was just looking at,
And the statute's attached to the motion if it helps the court.
yeah, I have a copy of the statute as well. I had a code of criminal procedures that's open before me. Give me a copy of that, the PC in this case. It's cause number 325709.
Your Honor, if notwithstanding, Mr. Shearer.
Hold on a minute. Now, Mr. Crawshaw, this is the gentleman in court is Attorney Lamar Johnson. He's a assistant district attorney with the Jefferson County District Attorney's Office.
Okay.
Okay. Now, Mr. Crawshaw, what were you saying? You had mentioned something about Mr. Shearer was handling the case.
Yeah, he emailed everybody when I emailed the motion to the court with the proposed order. He responded saying that he was not opposed.
Okay. Now, Mr. Johnson, you wanted to say something?
Yes, Your Honor. Notwithstanding Mr. Shearer's no objection to or no opposition to the motion, Your Honor, as a threshold matter, I don't believe the trial court has jurisdiction to. Well, I don't believe you have jurisdiction, Your Honor, as a county judge to preside over this proceeding, Your Honor. I believe this is supposed to be brought before the magistrate judge who orders the proceeding.
Okay. Now, Mr. Crawshaw, you have a response? I was looking at the code.
Yes, you do have jurisdiction over this. You have the case was
I think we're looking at let's see, Articles 18.19 Texas Code of Criminal Procedure.
Yeah, that's correct.
Section B says when a weapon described in paragraph A, well, let me read paragraph A. Weapon seized in connection with the with an offense involving the use of a weapon or an offense under Penal Code Chapter 46 shall be held by law enforcement agency making a seizure, subject to the following provisions. And then they talked about whether or not it's a weapon that is prohibited or a weapon alleged to have been stolen property. Now, in B, it says when a weapon described in paragraph 8 of this article is seized and the seizure is not made pursuant to a search or arrest warrant. And I think this was a inventory search or search incident to arrest. Is that correct?
Yes.
Okay. And let's see. Search warrant, arrest warrant, and delivered to a magistrate a written inventory of each weapon seized. Okay. Okay, if there's no prosecution or conviction for an offense involving the weapon seized, the magistrate to whom the seizure was reported shall, before the 61st day after the date the magistrate determines that there will be no prosecution or conviction, notify in writing the person found in possession of the weapon that the person is entitled to the weapon upon written request to the magistrate. The magistrate shall order the weapon returned to the person found in possession before the 61st day after the date the magistrate received a request from the person. If the weapon is not requested before the 61st day after the date of notification, the magistrate shall, before the 121st day after the date of notification, order the weapon be destroyed, sold, public sale. Okay. I think so. The main part of this statute in Article 19 of 18.19 states that the arresting officer or the seizing officer has to give a written inventory to a magistrate, and then that magistrate, within 61 days of being requested the return of the weapon, if the case has been dismissed, shall give the weapon back or return the weapon back to the defendant. I think that the issue is whether or not me as the judge in this court is the magistrate who received a written inventory. I don't think I've received a written inventory in this case. I don't know if the officer also, I don't know whether or not the officer gave a written inventory to another magistrate either.
Yeah, and my argument is that the case is dismissed.
I know.
And within 30 days, this court can make further orders as necessary to return my client's property to him.
Oh, you're talking about the court having like plenary jurisdiction, that's what you're saying?
That's right.
I understand that, but I'm saying in terms of the return of the weapon, the statute states that the arrest or the seizing officer has to give a written report to a magistrate. So my question is, do you know whether or not the arresting officer gave an inventory to a magistrate? Do we know that?
No, I don't know, and I don't know who the magistrate is other than you, Judge. And I'm looking at the annotations to that code provision. I've never done this any other way other than file this motion in the trial court.
I understand, but I'm just saying, just looking at the way they drafted the statute. Now you stated that you say you was looking at the annotations.
Mm-hmm.
Okay, and what does the annotation say?
Inasmuch as the state would be able to file a motion to forfeit the weapon if there had been a conviction or something like that, my position is that you have power to order the return. I'm looking at This was dealing with a weapon that's forfeited, and it says that the court's order forfeiting a 22 caliber. The court's order forfeiting a firearm was proper after a conviction.
That's after conviction, yeah.
And so, in as much as there's no conviction here, I would say it's analogous. This court I don't know who else can issue the order. I don't know who the magistrate is, other than you, Judge Holmes.
Yeah, I don't. Yeah, see, I don't know whether or not
It's certainly not my job. I don't think that the legislature wants me to have to track down the JP judge from 2019 if that person's still on the bench, and whoever set Mr. Ottery's bond, and have to get that person's permission.
I don't know. I think it's saying a magistrate that to whom the inventory. Let's see.
I'll pull up the discovery now. The state's probably be easier for them to pull it up. But when I'm looking at the discovery.
Two things. One, it looks like even if we accept the counsel position, it looks like the defendant was arraigned in County Court 3.
Okay. Okay. What they're saying is this. Okay, this case was transferred over here from County Court at Law number 3.
Okay.
So the Judge Woods was the original magistrate. Okay.
Okay.
So yeah. So that's how So I guess that we can. He would at least be one of the magistrates in line. What I'm saying is, either the DPS trooper gave a written inventory to either another magistrate, JP, or he may have given it to Judge Woods. I don't know. I'm just speculating right now, but I'm just trying to comply with, the language of the statute. So we was trying to find out who was the magistrate.
Well, and they haven't given him any notice that he's entitled to it. That says they shall give written notice. He doesn't have that yet.
No, I know, but you've already made your request.
That's right.
Right. So you've already, I guess, you've already made the request within a timely fashion or within a timely manner. So
we can't like transfer, I guess, what is it? We can't transfer this case back to a different court. No. What I'm saying is the way the statute is read, let's suppose there was a JP that the DPS trooper went to, and that magistrate have the written inventory. This statute was seen to suggest that that magistrate would have the jurisdiction to return the weapon back, because the way they wrote the statute, it says that there's no prosecution or conviction for an offense involving the weapon seized, the magistrate to whom the seizure was reported shall, before the 6th verse day ever occurred, that there will be no prosecution, notify in writing, found that he's entitled to it, and the magistrate shall order the weapon returned to that person. So that's right.
So
but go ahead, Judge. I shouldn't interrupt. Go ahead. Sorry.
It seemed like the way they wrote it, it seems like the magistrate to whom the seizure was reported is the magistrate that will order that the weapon would be returned. That's the way it reads.
But it's not exclusive.
Okay.
In other words, that statute doesn't say you can't do it.
It doesn't say may, it says shall.
It says that person shall, but it
Right.
also doesn't mean, it also doesn't rule out the court that had jurisdiction over the defendant. It doesn't say you can't.
Well,
And we
yeah,
do know.
It doesn't make any mention of that. It just
That's
only
right.
it only speaks to the magistrate to whom the weapon seized was reported.
Mhm.
Hold on. Okay, Mr.
Is that a
Johnson.
magistrate spanking? Is that, because there is a property inventory.
Oh, there's another magistrate?
I don't know if this is a magistrate judge. I don't.
No, he's looking in it. He's looking in his, in the courts, I mean, in the DA's file. Mr. Crawshaw?
Yes,
The
Judge.
prosecutor, I guess as you suggested, looked in their file, and there was some magistrate name that did do the inventory.
I certified that Spankies received the items described.
Oh, there is somebody that did the inventory. There's a magistrate. Let me ask you this here. Let's do this here. Mr. Crawshaw. Let me get the prosecutor. Can you send that to Mr. Crawshaw?
Yes, sir.
Okay, Mr. Crawshaw, let me do this here. Let me get off of YouTube.